My name is Sierra Sanderson, and I am an attorney with MNK Law. At MNK Law, we are more than just your attorney. Our mission is to listen, understand, solve, and execute challenges you face by being your business advisor as well. You may recall my colleague Ben Miller discussing clauses to get right in a master services agreement to avoid litigation. In this video, we will discuss 3 additional clauses to review and consider when signing a master services agreement to protect the rights and reputation of your business. To refresh your memory on master services agreements, when 2 businesses enter into a service transaction, they sometimes execute a master services agreement, commonly referred to as an MSA. It is common for our clients to either provide their customers with an MSA or come to us to review an MSA with a vendor they want to enter into business with. You can think of an MSA as a master contract that establishes the foundations of the parties' current and future contractual activities. MSAs provide terms that govern each subsequent transaction between the parties, such as payment terms, warranties, dispute resolution, and termination provisions. As a foundational contract, it is obviously critical to ensure your business's needs are met, but more importantly, that your business is protected. With this in mind, drafting an MSA will focus on different clauses depending on if you are the service provider or the customer. In this video, we will high-level discuss some clauses that you need to consider from both perspectives. Identifying all aspects of the services. To ensure both sides stay happy, that being the service provider and the customer, before service providers accept a statement of work, they should ensure that all the following critical service elements have been addressed. Now, this is assuming that the first statement of work is being executed concurrently with the MSA. The following items should be crystal clear when outlining the service provisions. 1. Project milestones. 2. Timing requirements. 3. Completion standards. 4. Fee schedules. And 5. Acceptance testing procedures. When this process is in place, it will ensure that the customer's expectations are clear, acceptable, and achievable. Next, obligations. It is important to ensure the service provider and customer obligations are clear and avoid any ambiguity that could lead to a dispute while executing the MSA. Now, for both parties, it would be best that a contract manager is appointed on each side to manage the services and the relationship with one another. Now, this will allow 3 things to happen. First, when there is one point of contact, strong customer support can be provided to resolve any issues that arise. Second, it ensures ambiguity is avoided when relating to who can act on the service provider or customer's behalf. And lastly, it will build stronger relationships that can be between the service provider and customer by choosing an individual best suited to be the face for the service provider and any particular customer. One note for customer obligations: service providers will want to ensure that they are not responsible for delays caused by customers' failure to obtain or provide necessary approvals, information licenses, and instructions on a timely basis. Confidentiality. Under most MSA arrangements, the service provider is more likely to receive the customer's information than the reverse. It will be important to consider whether a one-sided or mutual confidentiality provision should be employed. A service provider using any of its own intellectual property, proprietary skills, or knowledge in its performance of its services will likely object to a one-sided confidentiality provision and will want to draft a mutual one. General confidentiality provision templates may not specify any transaction-specific items that should be added to the list of confidential information. It is critical to have an attorney review your MSAs to avoid the possibility of dispute as to whether any disclosed information falls within the general list. Both parties should also consider adding language to this section if the parties have a need to create and enforce confidentiality provisions to cover their affiliates, employees, contractors, and any other representatives. Lastly, depending on the quantity of confidential information that is being disclosed between the parties, either side may want to consider entering into a separate, standalone confidentiality agreement. This sums up our tips on what you should take special care in reviewing before signing a master services agreement. If you have any questions or want to learn more on how we can assist you, In this process, you can reach out to info@mnklawyers.com for more information. Do not forget to like, comment, and subscribe. Thank you.